about today lawyer liability as we leave the first chapter on the regulatory framework of professional responsibility. And we started off with just looking at different parameters in practice and exploring the major themes in the book that we talked about in the preface, focusing on how lawyers assess risk, because that's what we're going to be doing most of this semester. And you see when we start talking about the general problems in the book, we're trying to interpret the rules, of course, but we're trying to do them in a practical context where we are the attorney and we have tried to resolve these issues. So one of the things that we talked about was institutions that regulate lawyers, and now we're going to start framing those type of institutions and look at how they impact the law. And so I emphasized a number of things. I talked about conflicts of interest. There are like 4 chapters that we're going to do in terms of conflicts of interest, so that's going to be interesting. Truthfulness, which is what we'll be spending a great deal on today. Lawyers' duties to the system. We talked about the lawyer as the officer of the court, so that may even mean you have to make a choice that may, on the surface, negatively impact your client's interests, but you're trying to juggle all of these interests. Our own personal interests, of course, and how that impacts our duties as fiduciaries, a position of utmost trust because of our expertise, self-interest in the regulation of lawyers, and then lawyers and institutional pressures on our judgments. All in the context of a changing legal profession. So that's what we did in our last class. And we looked at a couple of things in terms of making determinations. We wanted to think critically. We wanted to be able to interpret these rules. We wanted to be able to assess the context that we're in. And we also wanted to really try and answer 3 primary questions. Whether the conduct in question violates the ethical rules, whether there is some other law that could be violated, because we have to keep our eye not only on these rules of professional responsibility, but other law, and then what is the right thing to do. So I thought we would today sort of just jump into these last couple of problems in chapter 1, and then we'll start writing on chapter 2. So you see on page 52 is probably where we left off. And this is not to scare you, but the reason that the book is formatted this way is because basically the rules of professional responsibilities don't impact you until you become attorneys. But there is one rule, even now, that impacts your professional behavior, and that is 8.1. And our 8.1 in Kentucky is the same as the 8.1 in this rule book. And 8.1 is dealing with the admission to the practice of law. And you notice it applies both to law students and applicants to the bar, as well as lawyers. So even though I'm admitted somewhere, if I wanted to be admitted somewhere else, it would be the same thing that you would do. You're looking at your law school application, making sure it is the same as your bar application, then making sure you make all of the accurate and candid disclosures. Same thing for me. I would get all of my other jurisdictions, make sure they all say the same thing, then apply to the new one, make sure that I'm forthright in my disclosures. And so that's what 8.1 does. And what we're trying to sort of gauge this. Good moral character, and all of the other requirements, passing the bar, the MPRE, and then the dean of each law school certifies to the committee as to the character and fitness of each applicant. So we have this first problem that we have to deal with. this is I know it's sort of a little touchy-feely problem, kind of whatever, but it's interesting. What it's trying to do is sort of give you a little tension in terms of what does disclosure mean, how much should you disclose, is honesty the best policy? Yes. But if you are honest, what impact does that have? If you answer the questions too forthrightly, does that mean there'll be more questions? And certainly that is not a wink and nod to you to not disclose everything. I think the book emphasizes over and over again, and we do at the law school, that disclosure is the best policy, because if there are any inconsistencies or things that aren't fully resolved, that's when the bar office gets interested. So what about this problem? On page 52, it's trying to be funny and all that. Anyway. Okay. So, I mean, this could certainly happen. You could do it with controlled substances or anything else you should disclose. But notice, the reason it's set up this way is that we want you to sort of have to struggle with how to interpret this. Now, I'll say at the outset, you could interpret this so literally that, or formalistically, that you could say, well, I'm not disclosing anything. It's not current. I've stopped, and who's going to find out? Which in the real world is probably true. So look on page 52. Look at this. This is the case. Are you currently, or have you been, and this is from Iowa, and actual question on the Iowa bar. So whatever bar you're applying to, Kentucky, Indiana, Ohio, Tennessee, you want to start looking now at how the questions are framed, then assembling all of your information. Got to make it easier for you. So, but here's an Iowa example, and probably is just as intrusive as any jurisdiction that you'll be in. And so you have us as a third-year law student. We're in this particular situation, and it asks this question: are you currently, or have you been in the last 3 years engaged in the illegal use of drugs? If yes, complete the details below. We have a definition for illegal use of drugs, and it has this word currently. Currently does not mean on the day of, or even the weeks or months preceding the completion of this application. Rather, it means recently enough so that the condition of impairment may have an ongoing impact. And then there's a Fifth Amendment, I guess, exemption. If you assert the Fifth Amendment privilege against self-incrimination, you would choose to assert the Fifth Amendment privilege. You must do so in writing. And then you have this strange language on the top of page 53. Your application will be processed if you claim the Fifth Amendment privilege against self-incrimination. That's interesting language, will be processed. So we want to know what that means. Then on 53, we have the scenario. Several times during our 3 years in law school, so we're kind of in the time period, we've been at parties and we have partaken. The last time we did so was 3 weeks ago, but we're not going to do it again. And now that we've read this, we're not going to smoke anymore, at least not before you're admitted to the bar, the book said. There's a rumor that there was a KDA official or bar official answering questions. A question was asked, what happens if you answer affirmatively? So this is a student applicant saying, well, I'm going to comply. I'm going to be candid. I'm not involved in any criminal activity. I guess at least not officially. I'm going to fully disclose. And then the bar person says they would be denied admission to the bar. So that's the way the problem is set up. That probably was a little bit much in real life to say that, because the bar person should have said, I don't know the answer to that. We look at the whole record. It's a snapshot of time. We look at patterns of conduct, et cetera, et cetera. But we want this question to have some tension. So the answer is, if you tell, we're going to deny your admission to the bar. So what should we do? How will we answer this question? How are you going to answer this question? And I'm not going to sort of tell you all your options. I want you to come up with the options. What would you do? Number of different things. And you have 8.1 up here. And notice the 8.1 in our book, if you look at comment 2, it has that same Fifth Amendment privilege. So notice, it tells us the duty imposed by this rule extends to persons seeking admission to the bar as well as lawyers, like I said. Hence, if a person makes a material false statement in connection with an application, it may be basis for subsequent disciplinary action if the person is admitted. And in any event, may be relevant to a subsequent admission application. Applies to the lawyer's own admission or discipline, as well as that of others. So they also say it's a separate professional offense to knowingly make or misrepresent or omit something in the disciplinary investigation of the lawyer's own conduct. And paragraph B requires you to correct anything that could be seen as a misapprehension. So how do we answer this? How would you answer? You really want to get admitted, and you want to go ahead.
I mean, if you did it, then I guess the best thing to do.
Mr. Baker, right?
Yes.
Okay. Yeah.
Would be to assert your Fifth Amendment privilege and put the burden on the bar to investigate possible illicit drug use.
Yeah. Okay. That's good. No, I'm not. So it's there, and you're using it, and that's what lawyers do. You're already thinking like a lawyer, but have you thought about any consequences that might arise if you assert your right? Because it's kind of funny the way that it says, yeah, you can do it, and this application makes me kind of nervous. It says, yeah, you can do it, but it will be processed. I don't know what process means. Does that mean, okay, we're happy you're being honest and go ahead? Or does it mean we're processed, we're going to look at this, we're going to put it aside and come back? Or does it mean we don't even look at it, you just said it and that's great? So, have you thought about those consequences when you said put the burden on the Bar Association?
Yes. Yeah, I mean, because if you admit then, and you're found out to have lied, then that's two separate offenses, and you're definitely
Yeah, that's true. But will you cause yourself more problems by asserting this Fifth Amendment?
We don't know.
No? Ms. Cruz?
So I agree with Neil, that I think you're going to have consequences regardless. Like, you're going to probably be in trouble if you, plead the Fifth, because it makes your application look a little bit more suspicious, like you have something to hide.
Okay.
And then if you lie, you're in trouble anyway, because they're going to find out.
Okay. So now this is good. This is our first problem. I'm going to tell you what happens usually in real life. Not any substantive figures, but some people did assert this, and I'll tell you what happened, and you'll see. Go ahead. Yes.
For me, actually, assuming that if we assume that I'm able to provide the context in which it occurred, I would be candid and say it happened in this setting, and that is the only setting that it's happened in, and it has not impacted anything in my academics or in my personal life.
Okay. So Ms. Harper, right?
Yes.
You'll give a full explanation. Yeah, we're at this party, and that's good. What happens if they ask you who else was at the party? You're a law student, so you weren't doing this alone, were you? So, and you're not a lawyer. You're not a lawyer yet, but the reason I'm asking this question is it sort of sets up some things in our own lives as lawyers that if we see misconduct, we must tell. But even there, I'm going to point to a comment that talking about misconduct. You can't sort of report everything. It's sort of like crime. You can't report everything. Something happens every day. Someone jaywalks or someone samples the grapes at Kroger without paying for it or something like that. All of it, if you report it, you would go, so, but there has to be balance, and that's why you have this language substantial in the rule. Yeah.
What if you do the opposite and you give a very vague answer?
Say it like,
What if you do the opposite and you give a very vague answer?
Okay.
It was in the past, it's not current.
right, that's good. So now this is all about assessment of risk. So you assess the risk and say, well, I'll take a middle ground approach. I'll disclose what I did, say it's over with, not give too much detail. That might get you by, but it may also open up more questions. So they say, well, there are no time periods here. What are you talking about? Is it within the 3 years? Is it currently? When was the last time? So Ms. Harper's approach and your approach is sort of interesting. Ms. Moore, you're talking about sort of giving them enough to leave you alone, but there's always a danger that you don't give them enough, and then that opens up then. So you have a number of different options. Disclose, fully comply with 8.1 we said. Deny the use of controlled substances, that would be a lie, misrepresentation, don't do that. Wait to file the application. You really don't want to do that. You spend all this time and effort. You want to pass the bar and move on. Try admission in another state, maybe, but you still probably have some version of 8.1. That's not going to help. Plead the fifth. That's interesting. Sue the bar to say that this question is unconstitutional. That'll make some friends, right? And you could win, but you know it would take so long, or get legal advice. Well, I think there's no real way to tell how people answer these questions, but the authors of this book called up the Iowa Bar Association, and they didn't give exact figures, but they did give some anecdotal evidence. When people claim the fifth, you know the bar office called them in and just talked to them, and I don't know how deep the conversations were, but those people were admitted, usually without delay, but they certainly were called in. There was some questioning, but they were ultimately admitted. So disclosure, the book tells us, is the best approach. No narrow interpretations of what a truthful answer is under 8.1, at least the way it is set up. So that's good. Look at this next problem on page 56. The doctor's resume. So you see, these are little things that can happen. And you see that the next chapter will move from admission to practice into lawyer liability. So the book is trying to give you a realistic assessment of your life as a law student. Now you're moving into practice. And then chapter 2 is going to talk about all of the liability that you could be exposed to, from disciplinary, malpractice, civil and criminal liability, and the actions arising under those type of claims. So here we have, this is another real case. All of the cases are real. Here we have a doctorate resume. And so in a hyper-competitive legal profession, we have this person, Chris Cass, who's charged with an honor code violation. Now, someone take me through these violations and then give me an assessment. So this actually happened. I want you to talk about the violations, and then what is Chris Cass saying about these violations? And then I want you to sort of look at this case and make a decision. What should happen to this person? Wide range of things that we could do. And again, this is to emphasize regulation, conduct, and ultimately consequences if there is a violation. So what about this? Tell me. Ms. Horn, tell me what you think.
I'm not
So,
sure.
yeah, good. That's good. I want you to feel, some people are going to be sympathetic to this person, and then I want somebody real mean to say, well, what is this? I want a variety of viewpoints. So you say you don't know, Ms. Horn. Tell us why. Look at these violations and tell us what makes you unsure about this. The person is kind of sympathetic, I think. I mean, the pressures at home, we want to be successful. Cultural differences, I mean, I'm not excusing anything, but you come here in this competitive market, and then she comes from Estonia a year before. Her father's a diplomat, comes to the United States, and is very concerned about image, reputation, and achievement, particularly because everyone back in her home country is looking for her to succeed. So what makes you unsure about this, Ms. Moore? You said, I don't know.
I'm gonna be completely honest with you right now.
Yeah.
I took a pain pill like 30
Okay,
minutes ago,
okay.
so I'm kind of like not all here
All right,
right now.
that's good.
Honesty.
That was honest. That's good. Ms. Cruz, keep it up for me. What do you think about this person?
Can I be the mean one?
Yeah, that's fine.
Okay, so I think.
But why did you say, can I be the mean one? What makes you sort of angry about this? Yeah.
So I think she just described a whole bunch of people who were in law school, who go through the very same dilemmas, struggles, backgrounds, cultural diversities. So if you place her in that group, she just described a whole bunch of people that probably follow the rules and do things honestly and don't lie. And clearly she's easily influenced by other students as well to do things that might be unethical. And so it's a difficult situation that a lot of people probably would not approve of.
So you're saying everybody goes through this, she's just making excuses, and she should be punished accordingly.
Yeah, punish her.
Okay. I'm sorry. Tell me, I'm reading this wrong.
Yeah, I moved on you. I felt a little bit exposed over there, so I moved kind so I don't feel so vulnerable. Anyway, I'm Miss Greenwell. Hi, everybody. Okay, so Leanne just
The
went
class
really
is
hard.
lively today, so what happened? I went to that party last night. Go ahead.
Now I feel really exposed.
No, that's good.
So it's fine. Okay, so Leanne went pretty hard on this person, and I gotta say, I'm pretty sympathetic. Well, I'm always pretty sympathetic, so anyway, I'm a big softie. But like, I was thinking, I'm struggling in law school, and I can't even imagine like coming from a different country, and I can't even imagine what that's like. No clue in the world, like.
Yeah.
Not sure at all. So anyway, I feel like under these circumstances, if I was putting myself in this person's shoes, I would,
Okay.
maybe I would never lie on my resume, but I'm just saying,
Right.
like.
Right. You're making some good point. But see, notice your classmates are going to say this. Look at page 57. This is a killer, though. So I feel kind of sympathetic to her, too, but all through this, she knows that she's doing something wrong. I think the changes were all his ideas. First, she's shifting blame. She says, he was telling me to lie. That's not good. I knew it wasn't right, but also I needed a job, so I decided to take the advice. Obviously, it was a mistake. So all those pressures that you talk about give me empathy, and I'm sympathetic. But how do you resolve that with your sympathy? What about that?
I'm still feeling sympathetic. I'll be
Okay.
honest with you. Like, this is not compelling me because, like, honestly, like, I think, I don't know. I get it. Some people are very like easily peer pressured, and I feel like if I was like experiencing a lot of these things that she's experiencing, like,
Right.
man, I don't know. Like, I probably wouldn't know what to do either. Like, you're kind of looking at. I sound really sketchy right now. I sound like a really sketchy person.
I'm not letting you No. And you'll see there's a happy ending to this story, so it's good.
Okay,
So,
I love that.
Yeah, but yeah.
Okay. But yeah, I mean,
Tell me, Miss.
Taylor.
Okay, Miss Taylor. Okay.
Yes. I don't know. I'm the complete opposite. I think that in that situation, she took zero responsibility for her actions, and I think it would be different if she lied and then came forward and said, like, she wasn't placing the blame on other people.
Okay.
But she 100% used a scapegoat, and then on top of that, if I was another student and found out someone was lying on their resume and they got a job or an interview that I didn't get, and
Yeah.
I was in the same, if I was kind of in the same level as them, I'd be really mad.
Yeah.
So.
Yeah. That's right. Miss Harper.
For me, I think there does need to be some punishment because
A little bit louder.
I do think there needs to be a punishment given because,
Yeah.
as most people pointed out, she knew what she was doing was wrong. However, with the circumstances that she was in, because I do sympathize with the fact that she's new to the country, she doesn't understand how things work here 100%, and she does seem to be, it does seem like this other person could have had a lot of influence over her. I don't think the punishment should be the maximum punishment.
Okay.
If there's a lesser punishment, that should be the punishment given.
Okay.
I don't think she should get off scot-free, but I don't think this
Okay.
should be like a career ender.
So the fact that she knew that she was wrong will play into it, even though she comes from another country. But she says 2 or 3 times that it's a lie. Obviously, it was a mistake. I know it was wrong. It was all his idea. So that sort of lessen your sympathy and move you to a more harsh penalty.
Possibly, I would need to hear, honestly, if she was like speaking in front of the disciplinary board, like if I were able to hear how she was speaking, like the tone of her voice, what she was saying, like see her express the facial expression she's making, that would probably actually, that could change my opinion either way because I could be able to kind of gauge how truthful she was being, like maybe whether she was actually sorry about what she did or whether what she's saying is 100% true.
Okay. Okay. Ms. Greenwald,
She was sorry.
then Mr. Johnson.
I feel like she was sorry. So
So-
that makes me feel.
So that's okay. I'm sorry, and that's good.
Listen, I'm such a pushover. But yeah, I mean, I feel like the fact that she was remorseful really does it for me. Because when people that I don't have sympathy for are the people
I
that.
think the charges were all his ideas.
Oh.
That's the killer that jumped out at me, though. But go ahead.
Okay, well, proceeding with that in mind. But she's still kind of stop. I'm digging my hole.
That's
even
okay.
deeper.
Go ahead.
We have to have somebody in here. That's
Yeah.
Okay. All right. But like the fact that she was resentful really helps here.
Okay.
For me, because the people that I don't feel sympathy for, like the only people in the whole world that I don't feel sympathy for, are the people who are like, yeah, I blatantly did this. I'm not sorry for it. Like absolutely, like not at all. Like don't try and right their wrongs.
Okay. So before I move away from you, tell me what type of penalty you would impose.
Not a super strict one. Like there would be a penalty. They can't just get away with this, I guess.
Right.
But I mean, you know that I want to be a criminal defense attorney. But anyway.
But see, you're illustrating. I know we're sort of laughing about, but this is the tension with a self-regulated profession. And people look at us and say, "Oh yeah, there's discipline and everything," but we're disciplining ourselves. And so there is some public skepticism about how we discipline ourselves. Mr. Johnson, go ahead.
I don't know. I get both sides. She's a third-year student. I don't think I'd kick her out of law school. But there's probably factors around it. Her whole character going through 3 years. People know her.
Right.
Has she done certain things before? How is she in the community, in the law school? So we could take all that into account.
Right.
And look at that as a whole kind of thing for her.
But you know what's interesting? Everybody is talking generally. This is interesting, sort of the humanistic side, talking about her, the cultural thing. And I sort of set the question up like this. And you feel empathy, or maybe you want to be a little bit harsh, but no one's really analyzing what she did and what impact that has on good moral character and fitness. And she says she graduated with Latin honors. Not true. She misrepresents where she finished in class. She photoshopped changes to her transcript. And in the real case, that's how it came. This is probably an older case, like from the 90s, but you used to have to submit your resume to the Office of Career Development, and they would send them out to the law firms, and someone noticed that it had been sort of whited out and altered, and then that's what got the ball rolling in terms of the honor code. And so she did that, and then she says she's a cultural attaché when she was really a file clerk. That's whatever. But I mean, I think you have three things you could do. You could expel her, but if you expel her from law school, that's going to undermine her ability to practice. She's going to be precluded from the practice of law. May even have to start all over again. We could say violation of the honor code and more ethics education as a sanction. Or we could say just a warning. Don't ever do this again. What do you think happened in real life?
Violation of honor?
I'm sorry?
Never mind.
What happened in real life, you think? It's a happy ending. She's practicing law now. She came through all of this and she's practicing law now. But what do you think happened to her in terms of punishment?
An honor code violation? Not expelled?
Yeah, that was part of it, but what do you think? Yeah.
I'll try to redeem myself.
No, you can. Go ahead.
Probably my guess would be like ethics classes and things.
Yeah, that's why. In some cases, I'll tell you this, y'all are gonna laugh. Sometimes, if an attorney gets an ethical violation and it's horrible, really bad, make them take the professional responsibility exam again. That's the same. Yeah. So, go ahead.
Maybe like a suspension for
Yeah,
a year or so.
that's one too. Mr. Johnson. Okay, this is what happened. She was suspended from law school for 1 year.
Yeah.
She had to undergo counseling and additional training in professional responsibility. She had to send letters of apology to the firms where her false information was submitted. And after she completed those conditions, the Office of Bar Counsel looked at it and she was granted the privilege of practicing law. She now practices law. So that's good. Now we're starting on the substantive part of the class. This is sort of the soft part of the class still, but we're going to start moving into the rules, and we're going to see a number of different rules now when we talk about lawyer liability. So in this chapter, we're going to be doing basically three things. One is we're going to talk about the ethical duty to report misconduct. We sort of talked about that a little bit already. The ethical duty to report misconduct. So that is one of the cornerstone components of having a self-regulatory system. So we made all of this, we made a big deal about inherent authority, the difference between the court sort of making the rules as opposed to the legislature. A component of that is the ethical duty to report misconduct. Then we're going to talk about duties of supervisory and subordinate lawyers. So the ethical duty to report misconduct, duties of supervisory and subordinate lawyers, the basis of civil liability and legal malpractice, and then a bit about criminal liability. So if you turn to page 60, there are a number of, and this is why we sort of looked at this last problem. We're talking about a student applicant to the bar, but if you're an attorney, there are various forms of professional discipline. Disbarment is the worst. That's usually up to 5 years. And you see you can be reinstated. President Clinton was reinstated to the bar. President Nixon was not. Disbarment, you could have suspension, you could have reprimand, and there's other types of sanctions as well. Reprimands can be private, so you never hear about them, just people inside the legal community. Or they could be public. That's when they print them in a bar journal or something, or in a Supreme Court opinion. So the Office of Bar Counsel is really an agent of the Kentucky Supreme Court and investigates complaints. And a lot of state systems do this. The Ohio Supreme Court will have an office of lawyer discipline. All the jurisdictions have some variation of that. Now, look at this problem. It's not a problem, it's an example on page 62. How do you explain something like this? Prominent lawyer, former state legislator, held in contempt and reprimanded 4 times by the bar. Not showing up in court. This person just doesn't show up in court. And I think he's a pretty good lawyer, but he never shows up. Twice the courts imposed suspended jail sentences. He defaulted on 4 appeals, lied to clients. You know, things have lapsed and then the client calls, oh, it's still pending, I'm working on it, that type of thing. Horrible type of conduct. And the only punishment he gets is 90 days. So how do we explain something like this in the context of a self-regulated profession? So despite this parade of conduct you see in the middle of page 60, a court considering the state bar's complaint against him suspended his law license for only 90 days. The state bar wanted to disbar him, but the Virginia Supreme Court affirmed the light sanction. You even have a judge in here being quoted in open court. Yeah, I play golf with this guy all the time, and if I was in trouble, I wouldn't hesitate to hire him if I could get him to court. So what does that say about us? How do you explain this? The so-called reason that we have these rules is so that we can protect the public, and we want the public to have confidence in our regulation. Yeah, sorry.
Well, this particular example given, it reminds me an awful lot of what's known in law enforcement as the blue curtain, kind of feeling almost like we should protect our own. That's what it seems to be screaming out to me here. The fact that this judge, admitted that he's played golf with Robson before, that means, to me at least, that judge should have recused himself from this hearing at all, because he has that personal connection to the person at issue. And the fact that he didn't, that raises questions not only about Mr. Robson's conduct, but this judge's conduct as well.
That's right. That's right. And so I think what we're pointing to, we're not going to solve this problem here, is some structural problems with the way that the system of discipline is set up. And that's what you're going to have, some tension when you have a self-regulated profession. Another thing, in light of these light sentences, sanctions I should say, is under enforcement. I mean, everything that is really bad that happens in our profession isn't subject to discipline. In fact, there's this discussion of under enforcement. You know, the officers are overworked, and so what we will do is pick the most serious cases and try and deal with them. But on the top of page 65, there's an interesting thing that we should discuss. If the disciplinary agencies tend to under-enforce the rules, does that mean that lawyers need not worry about compliance with the ethics rules? And another way to put it is, since there's a very low likelihood that you'll be caught doing anything, should you even pay attention to these rules? Yes?
Well, it talks about, you can also get sued for legal malpractice. So it's not just the self-reporting issue, but you can be held personally liable for this stuff.
That's right, that's right. And it's another component of self-regulation. We all have to take these rules seriously if they're going to have substance. And the point you're making is that you open yourself up even to more liability if you don't take these rules seriously. Now, 1.2 is an important rule, and it's our first really substantive rule. And I want someone to sort of break this rule down for us, because that's going to help us discuss this first problem in chapter 2. And you'll notice this is another, we talked about sympathy and empathy before. This problem in chapter 2, the dying mother really tugs at your heartstrings, but we still have this rule. We have rule 1.2b. 1.2b. to tell me what 1.2D says, and then how do you interpret it? It's going to help us look at this first problem. So this is mandatory. Shall not counsel client to engage or assist a client conduct the lawyer. There's that word again, knows it's criminal or fraud. So client comes to your office and says, I'm thinking of doing a new type of securities transaction. This is something I've invented. I've read a lot of books about securities, read a lot of law review articles, and I come up with a new theory of how to finance debt through electronic transfers. No one has ever done it before, and the laws that are on the books seem to be ambiguous, but if you read it one way, it could be illegal. Client comes to you and says that. Now, if you give advice on that, are you assisting that client in something that you know to be criminal or fraudulent? Would you be precluded from advising that client under Rule 1.2D? Yeah.
No, not unless you were trying to tell them, oh, here's a way to do it without getting caught.
Okay.
But if you're telling them, just advising them.
That's good. Now, what makes you say that? That's the right answer. But how did you make that distinction?
Because, well, the rest of the rule
Yeah.
says that you can give advice and you can counsel or assist the client to make a good faith effort.
Right.
And basically obey the law.
Right, that's good, that's good. And so, notice, that's very important because you have to know the distinction between those two types of advices to be an effective and competent lawyer. You don't want to turn away your client if you